Hello, everyone, and welcome back to part 10 of Polity Premier League 2025. Let's begin. First question. With reference to the part 1, the first part of the Indian Constitution, which of the following statements is or are correct? The names and boundaries of states can be altered by the Parliament through a constitutional amendment under Article 368. So, see, as far as the first part is concerned, this provision relates to Article 3, and we know very well that alteration of names, boundaries, etc., can be done by the Parliament by law, and there is no need to opt for the procedure under Article 368. So, one is wrong. Second one, Article 3 requires prior recommendation of the President before a bill affecting state boundaries is introduced in the Parliament. Absolutely correct. This prior recommendation is required for such bills, the reorganization bills. Number 3, the consent of the concerned state legislature is mandatory before altering its boundaries. No, in India, this consultation is not mandatory. It is, of course, mandatory in countries like USA, in countries like Australia, but not in India. And hence, India is an indestructible union of destructible states, where states' boundaries can be destroyed without the consent, the permission of the respective states. So, right answer is B, 2 only. Next question. Consider the following provisions under Part 2 of the Constitution. A person who voluntarily acquires citizenship of another country automatically loses Indian citizenship under the Constitution. Yes, absolutely correct. This is a provision of the Constitution as well as the Citizenship Act of the year 1955. So, one is correct. Parliament has exclusive power to legislate on matters relating to acquisition and termination of Indian citizenship. Yes, citizenship is a unionist subject, and that is why the Parliament has exclusive authority to legislate on matters concerning citizenship. Number 3, the Constitution itself provides detailed procedures for granting citizenship to foreigners post 1950. So, this is wrong. Why? Because the Parliament has left it on the Constitution rather has left it on the Parliament to decide. And that is why we had made this law called the Citizenship Act 1955 to provide for citizenship for foreigners through a process of registration or naturalization. Okay, so 1 and 2 are right, 3 is wrong. Right answer is B, 1 and 2 only. Next question. Which of the following statements regarding UTs is or are correct? Parliament can convert a union territory into a full-fledged state through a simple law under Article 3. Yes, this is correct. The Constitution provides a uniform administrative framework for all UTs. No. Some UTs have state legislatures, others don't. So there is no uniformity in the administrative framework. Number 3, the President administers UTs through administrators appointed under Article 239 is absolutely correct. These administrators can be called as, of course, administrators for certain UTs, or they can also be called LG, Lieutenant Governor, for 5 UTs. So, of course, UTs of Delhi, Pondicherry or Puducherry, UT of Ladakh, and J&K. Their administrators are known as LGs. Please write in the comment section the name of the 5th UT, where the administrator is also referred to as the Lieutenant Governor. Anyway, the right answer for this question is A, 1 and 3 only. Next question. With reference to the governance of scheduled areas under the 5th and 6th schedules of the Constitution, consider the following statements. The governor has the power to direct that a central or state act shall not apply to a Schedule 5 or scheduled area under Schedule 5. Yes, correct. In the 6th schedule, a law made by the state legislature shall not apply to an autonomous district council unless directed by the council itself is also correct. So under Schedule 5 areas, we have the concept of TAC, Tribal Advisory Council. Under Schedule 6, we have the concept of ADCs, Autonomous District Councils. And these ADCs have executive powers, they have legislative powers, they have financial powers, and they also have their own judicial system, a two-tier court structure. So anyway, 2 is also correct. Number 3, the 5th schedule provides for autonomous district councils similar to those in the 6th schedule. This is wrong. The 5th schedule provides for tribal advisory council. The 6th schedule is what provides for autonomous district councils. So 1 and 2 are right. A is the right answer. Moving on to the next question with reference to the 6th schedule of the Indian Constitution. Consider the following statements. The ADCs have the power to make laws on land, forest management, and public health. Yes or no? Yes, of course, they have legislative functions to perform. The governor has the power to include or exclude any new tribal areas from the 6th schedule through a public notification. Yes, that is also correct. And the laws made by an ADC require approval of the state legislature to come into force. No, this approval is not required. 3 is wrong. Right answer A, 1 and 2 only. So the next question is, which of the following statements regarding the administration of UTs under Part 8 is correct? Article 239 capital A mandates that every UT with a legislature must have a council of ministers. No, this is actually wrong. So this article says that we can create local legislatures or council of ministers or both for certain UTs. For example, in this particular article, the very first clause says that Parliament by law may. So Parliament may, as an optional provision, by law create for the UT of Pondicherry, of course, a body which would be partly elected, partly nominated, and a council of ministers. So it is an optional provision. There is no such mandate. So A is wrong. The Delhi Assembly has the same legislative powers as a state legislature under Article 246, which is what? Schedule 7. So of course this is wrong because the Delhi Assembly has no power to make laws on certain stateless subjects like 1 to 18 and of course those related topics towards the end of the list. That is public order, police, land and other related topics. So 2 is also wrong, or B is also wrong. C, the administrators appointed under this Article 239 are required to act on the advice of Council of Ministers in all UTs. Of course not. All UTs don't have, firstly, what? The Council of Ministers. So this is also wrong. D, none of the above is the correct answer. Moving on to the next question. With respect to the 5th schedule, which of the following is a power exclusively vested in the governor of a state with scheduled areas? To establish ADCs. ADCs are bodies under which schedule? Under 6th schedule. To direct that a law passed by parliament shall not apply to a scheduled area with modifications. Yes, this is the right answer. To levy taxes on minor forest produce in scheduled areas, no. And to appoint members of the TAC without state government consultation is also no. So right answer is B. Next question. Which of the following statements about the 6th schedule is correct? The governor can dissolve an ADC without consulting the state legislature. Yes, absolutely correct. The governor can dissolve the ADC without consulting the state legislature. This is right. ADCs have the power to establish village councils, but no power to regulate money lending. So they can also regulate money lending activities. C, the 6th schedule applies to tribal areas in Assam. Yes, of course. Meghalaya, yes. Tripura and Arunachal. So that is wrong. Anyway, please type in the comment section which is the 4th state which comes under Schedule 6 areas or which has these ADCs. And D, laws made by ADCs on land use require the governor's assent only if they conflict with state laws. No, not really. Laws made by ADCs might require governor's assent otherwise also. So this is incorrect. Right answer is A. Moving on to the next question. This is a question on CAA 2019. Interesting. So the act applies only to migrants from Afghanistan, Bangladesh, and Pakistan who entered India on or before 31st December. Yes, of course, yes. It grants citizenship to all persecuted religious minorities from the mentioned countries, including Jews and Baha'is. Of course not. Not all and not these communities. So 2 is wrong. The act does not apply to tribal areas under the 6th schedule or the states under the inner line permit system. This is correct. So 1 and 3 are right. A is the right answer. Next, Consider the following statements regarding the governance of National Capital Territory of Delhi. The leader of the majority party is invited by the LG to become the chief minister. The leader of majority party is invited by the LG or is invited by the president who appoints the CM of Delhi, not the LG but the president. So one is wrong. The maximum number of ministers in Delhi cannot exceed 10% of the total strength of the Legislative Assembly. This point is interestingly correct. Though for other states, this number is how much? 15%, but for Delhi, it's 10%. The Assembly can make laws on all stateless subjects except police, land, and public order. This is true. The Council of Ministers in Delhi is responsible to the Lieutenant Governor and not to the Assembly. Why will the Council be responsible to LG? They are always responsible to the Legislative Assembly. So 4 is wrong, 2 and 3, A is the right answer. Next question, which of the following statements regarding the effect of national emergency are correct? Parliament acquires the power to legislate on stateless subjects. Okay, interesting. So this is actually correct. During a national emergency under Article 250, the Parliament does get the power to legislate on stateless subjects. And just to clarify, the states continue to enjoy making powers on these topics. But yes, when it comes to conflict, the central law will prevail. Number 2, the President can suspend the right to move any court for the enforcement of fundamental rights, including Articles 20 and 21, not including excluding. This change was made already through the Amendment Act. Which Amendment Act made this change? Please write in the comment section. And also, if you're aware, this was a very infamous case called the ADM Jabalpur versus Shivkant Shukla of 1976, where the Supreme Court actually upheld that the government has a right to even take away Article 21 during a national emergency. Anyway, so 2 is wrong. Number 3, the duration of Lok Sabha can be extended by 1 year at a time. Yes, during a national emergency, the duration of Lok Sabha can be extended by 1 year at a time, like it was done in the year 1976, extended twice. So right answer is 1 and 3, which is B. Then the next question, during a proclamation of emergency under Article 352, which of the following require ratification by the Parliament? So when the emergency is imposed on the grounds of war, external aggression, or armed rebellion, initially we had this term called internal disturbance. This term was replaced with armed rebellion through an Amendment Act. That was the 44th Amendment Act of the year what? 1978. When this emergency is imposed, you have to get it approved by the Parliament within 1 month. So A is right. And also this ratification, this approval needs what kind of majority? It needs a special majority. Okay. So A is the right answer. Any ordinance issued under Article 123 makes no sense. Any law enacted by Parliament on matters in stateless? No, not really. And suspension of rights under Article 19. Interestingly, the moment national emergency comes into force on grounds of war or grounds of external aggression, your Article 19 gets suspended immediately. There is no need for any approval, any presidential order. So right answer is of course A. Next question. Consider the following statements regarding financial emergency. It can remain in force indefinitely until revoked by the president. Yes, that's the beauty of a financial emergency. Under Article 360, it can remain in force till it is revoked by the president. There is no way for the parliament to interfere and end a financial emergency, unlike in the case of a national emergency, which can be ended by the or revoked by the parliament, or in the case of president's rule, which is subject to automatic removal or revocation after 3 years. And if you want to extend it beyond 3 years, we have to use the provision of Article 368, a constitutional amendment. Anyway, 1 is correct. Number 2, it has been invoked only once. Invoked only once is wrong because financial emergency has never been invoked. But please write in the comment section how many times have we seen a national emergency in the country? And as far as President's rule is concerned, of course, more than 115 times. So 2 is wrong. During its operation, the President can issue directions to reduce the salaries of judges of the Supreme Court and High Courts. Yes, any class of person's salaries can be reduced. So 3 is correct. 1 and 3. B is the right answer. Next question. Which of the following features of Indian Constitution do not support federalism? So we have to point out to what kind of features? We have to point out to those features which are unitary in nature, not the federal features. So single citizenship, yes, it is a unitary feature. Dual citizenship does not exist in the Indian Constitution. Independent judiciary is actually a federal feature. So this is wrong. And integrated election machinery, meaning a common machinery for both central and states, which is the very independent, upright, and honest body called the Election Commission of India. This is actually a unitary feature. So 1 and 4 are right. C. These two are not supportive of the federal structure in the country. This brings us to the last question for today. Which of the following conditions must be satisfied for a proclamation under Article 356 to be valid and legally sustainable? Okay. The proclamation must be approved by both houses of the parliament within 2 months. Fair enough. As far as the article is concerned, it refers to President's rule. So it must be approved by the houses within 2 months with what kind of majority? A simple majority. Number 2. The state legislative assembly is always dissolved immediately on the proclamation is wrong. After the S.R. Bommai judgment, what's the structure? You firstly dismiss the state government. After the imposition of President's rule, the first task is the state government has to be dismissed. And then the approval takes place in the parliament within how many months? 2 months. And then you go on to dissolve the state legislative assembly. So 2 is wrong. The president must be satisfied that the governance of the state cannot be carried on in accordance with the provisions of the constitution. Absolutely correct. So right answer is C, 1 and 3 only. This brings us to an end of our discussion today. Let's meet again in the next video. Till then, that is all for me. Jai Hind.